Wait, what? I can do that? This is Eric Bell with Wait, What? Financial matters that matter for business and the people that own them. Today I'm fortunate to have Bob Lamb with me from Cummins & White law firm here in Newport Beach. Bob joined Cummins & White as an associate in 2005 and became a partner in 2008. He's a third-generation estate planning attorney and has extensive experience planning and drafting foundational estate planning documents consistent of revocable living trusts, wills, living wills, and powers of attorney for healthcare and asset management. In addition, he successfully helps multi-generational families transfer their business interests to succeeding generations through the use of more advanced estate planning techniques, including intentional defective grantor trusts, grantor retained annuity trusts, irrevocable life insurance trusts, and dynasty trusts. Bob works with families, family offices, and other professionals to help them through the probate and estate settlement process, to administer trusts, to prepare tax returns, and to resolve trust and estate disputes. Another tidbit about Bob is he was an Army JAG Corps for 14 years in the military. Bob is licensed to practice law in the state of California and Florida, but that doesn't stop him from collaborating or partnering with attorneys in different states. Areas of practice are estate planning, trust administration, taxation, asset protection, probate, succession planning, and charitable giving. Thanks for being with me today, Bob.
Nice to be here.
You know, looking at your bio, is there anything else I should say about you other than you're a family man?
I like to barbecue. So it is the barbecue season, so we'll be hitting it pretty heavy this weekend.
All right. Yeah, I want to get into some basic questions about estate planning, and if you can, and we'll kind of segue into maybe a business question or two and get your overview on how your business and estate should work together. Can you tell me what happens if you have no estate plan?
Well, what a lot of people don't know is that you do have an estate plan. Even if you have nothing down in writing, you have an estate plan. And in California and other states, it's called the probate code. So if you don't have a plan, don't worry. Your state has a plan for you. And that has some consequences, meaning that people may be getting your property, that you don't want them to receive anything. People may be running your estate, even though you don't want them to. And people may be named the guardians of your minor children, even if you think that their appointment may be inappropriate.
So if you don't have a plan, the government will have a plan for you?
Yeah, absolutely.
All right. Wow. So what is a will?
So a will is a document that is really your statement of wishes, what you want to have happen to your property when you pass away. And I think everyone knows what it is. It can be on a simple piece of paper, on a cocktail napkin, really, if it's a holographic will, where it may say something like, I hereby want to leave my baseball card collection to Joe Smith, signed and dated and witnessed. But what a lot of people don't understand is that with the will, and at least here in California, it doesn't avoid probate. So even though you have a document that talks about where you want your property to go when you pass away, it does not prevent you from going to, not you, but your successors, from having to go to the court and probate the will.
What exactly is probate, Bob? I think a lot of people don't understand what probate means exactly.
Well, a probate, think of it as a administrative proceeding. So when you die, the assets in your name, in order to go ahead and pass title, you have to go through this court proceeding, this court process. And so that involves filing a petition for probate, sending out a notice to creditors, determining who those creditors are, doing an inventory of your assets, determining who the beneficiaries are. And that takes a long time. Here in California, it takes at least a year, but realistically, it's a year and a half, 2 years. A lot of people don't like that because not only does it take a long time, but it's very expensive. So you can think of tens of thousands of dollars that are going to attorneys and executors instead of your families.
So are there any assets that might avoid probate, or are all assets go through probate?
Well, not all assets go through probate. So the assets that go through probate are the assets that are in your individual name, that don't have some type of beneficiary designation, don't have some type of payable on death provision. But the assets that typically avoid probate are things that we're all familiar with. For instance, life insurance. So on your life insurance policy, you'll have the beneficiary form. And you go ahead and you fill out that beneficiary form. You name the people that you want to receive that policy on your passing. Another example would be an IRA account or some type of 401k plan that you have at work. Typically, you go ahead and you name a beneficiary, or maybe two, in case those that you've named as primary have passed away. What a lot of people don't understand about that as well is that if you do not fill out those forms, or let's say the people that you've named as the beneficiaries have passed away and there are no successors listed, and the default is the estate, the consequence of that is that the asset's still going to be probated.
Wow. I've always heard that you could avoid probate by having a living trust. Can you talk more about living trust and why you should have one?
Right. So trusts are one of those mechanisms where people go ahead and avoid probate. And you think of a trust as a contract, if you will. And in that contract, you have different players. You have the trustors. Those are the people that create it. You have the people that manage it. That's the trustees. And then we have what we all want to be. It's the beneficiaries. And so when you go ahead and fund this contract, you go ahead and you put your house into it, your investment accounts, much of your property. Funded trust, by definition, by statute, it's not something that's subject to probate. I mean, there's a huge advantage to that, is typically to go ahead and administer a trust. It doesn't cost as much money. It doesn't take the same amount of time. And unlike a probate, it's typically not a public proceeding. See, when you go through a probate, when you file all these papers with the court, that means that anyone can go down to the courthouse. They can go to the clerk's office. They can go ahead and pull your file, and they can go ahead and take a look at all the assets that you have, all the creditors that you have, who your beneficiaries are. And I don't know about you, but a lot of people are concerned about their privacy.
Right.
That doesn't happen with a probate.
What is the estate exemption now?
Well, I think you mean the estate tax exemption. So the amount that you can pass on to your heirs at your passing or give away total during your life is $11.4 million per person. Wow. It's a lot. But what a lot of people need to know is that the way that the law is set now, that $11.4 million starting on January 1st, 2026, falls to $5.4 million.
Wow.
So we only have this for a few more years.
$10.8 million come 2026.
Combined
between husband and wife, right? And you think it's going to stay there, or you think it might go lower? It just depends on what's going on in terms of taxes.
You know, if I knew, maybe I'd be doing something different. I remember years ago, we were in a similar situation. I think this was 2012. I refer to that year as Taxmageddon. And a lot of us in the estate planning field thought that the exemption was going to fall down to $1 million per person. It never happened. As a matter of fact, it went the exact opposite direction. So instead of the exemption decreasing, it actually increased. We got a lot better result than we thought we were. And if you take a look at the history of the estate tax anyway, it seemed like that exemption keeps getting higher and higher and higher. And so if you take a look at the historical trend, you would think that maybe it stays the same or maybe increases a little. However, I was at a seminar not too long ago, and one of the speakers brought up an interesting point. He said, we're in a political environment now where it seems that the incoming administration is set on undoing everything that the prior administration did. And so we've got an election coming up in, 2020?
Correct.
For those of you that are paying attention at home. And if you have a sea change in Congress and you have a change in the presidency, maybe that exemption doesn't stay at 11. And then maybe it decreases sooner. Who knows?
So not to confuse the two, but if you could explain to me, so the exemption right now is $11.4 million per spouse.
That's correct.
Do I still need a living trust?
You still need one, even if you're not worried about taxes.
Okay.
And the reason, and I'm talking in California, but I'm thinking in a lot of other states as well, the reason why that you're going to want the trust, if for nothing else, is to go ahead and avoid probate. For the reasons that I discussed before. Time of administration, the cost, and the public nature of a probate. See, the trust goes ahead and avoids all of that.
Mm-hmm. And I was going to ask you, Bob, how often or when should you review your trust? Because it seems like some people, they've done it 30 years ago, but some adjustments or amendments should be done. So I'm wondering at what times or what trigger things should people take a look at their trust and possibly renew it or amend it?
Yeah, that's a good question. I always tell people, take a look at your trust maybe every other year. And the things that you're going to be looking at are things such as, who are the beneficiaries in your trust? When are they going to receive those distributions when you pass away? Maybe you want to change those. Take a look at who you've named as the successor trustees. Are those people still the people that you want to manage your estate when you pass away? And I can't tell you how many times I've had someone do a trust maybe 10 years ago, and they take a look at their document, and they forgot who they even listed as trustee. And many times they say, well, this person's dead. We need to go ahead and remove them. Or I don't talk to this person anymore because I don't like them. We've had a falling out. Mm-hmm. Or why am I giving this person money? They haven't been good to me the last few years. So those are typically the things that necessitate changes. And then, of course, every once in a while we have changes to the tax law, and that would require review as well. So I would say take a look at it every other year. Doesn't mean you have to change it, but at least go ahead and revisit it every other year.
As far as successor trustees, do you recommend a corporate trustee or an individual or a combination of the two?
Well, when I first started practicing, I didn't use corporate trustees that often. A lot of times people used family members, friends. But, the more that I've been in practice and the more that I've seen family disputes,
Right.
I'm using them more and more. And it's not an easy job to go ahead, and especially in larger estates, where maybe you have someone that has business interests and they have real estate holdings, or maybe they have other types of investments. See, there's a lot of things that a trustee has to do to effectively manage the trust and keep themselves out of hot water too. I think another problem as well is when you have perhaps, these blended families, second marriages, kids from prior marriages, and kids don't necessarily trust one another.
Right.
And in that situation, a corporate trustee is just, it's invaluable. And the funny thing is when you talk to people about corporate trustees, they go, well, that's going to cost a lot of money. But what they don't realize is that the litigation that may result from beneficiaries and trustees that don't get along, it's far more expensive than anything that the corporate trustee is going to charge.
That's what I was thinking. And I've seen trusts, and you and I have seen them, where there's possibly a son or a daughter in conjunction with a corporate trustee, so they're both working together.
I've seen that at work.
And then the corporate trustee can play the bad guy,
yes,
for lack of another word.
Yes.
In decisions that need to be made. And let me ask you about the annual gift exclusion. How does that work?
So the annual gift exclusion, that's $15,000 a year. And so people ask me all the time, well, how much can I give away without having to pay any tax? And really what they're talking about is this: how much can I go ahead and give away each year when I don't have to file a return? And that amount is $15,000. And that can be to multiple people.
Okay.
It can be $15,000 to your kids, $15,000 to your grandkids, your friends, your neighbors, distant relatives, your favorite estate planning attorney. It doesn't matter. It can be $15,000 per person. And a lot of people do that when it looks like they may have an estate tax problem down the road. So remember, we're talking about that $11.4 million exemption. Well, if they come in under that, they don't have to worry about estate tax, which is 40% over that 11.4.
Wow, estate tax is 40. What about California? Is there an estate tax from California?
There is no estate tax in California right now, although there has been some proposed legislation that would go ahead and impose an estate tax in California.
But there could be a estate tax in other states.
There are some states that do have an estate tax.
Okay.
Inheritance taxes specifically, they'll work a little bit different. But bottom line is it reduces the amount that the beneficiaries are going to receive.
Yeah, I know the state of Washington has a
right.
estate tax. Yeah,
That's right.
And I kind of want to flip the script, Bob, and talk about more business and just give you a scenario and get your thoughts on it. And this is a client of mine, a real-life situation. Husband and wife start a team, metal shop. Son worked in the business for a year since he was like 16. He's now 40. Dad's in his mid to late 60s, going to retire or wants to retire. The son, by the employees and all other people, seem to be the heir apparent. Mm-hmm. Now, in the meantime, the daughter went to college, got her degree, and she's the CFO of the company.
Right.
So she thought because of her education and so forth, she would be the heir apparent. So right now, son and daughter are not talking because they're mad at each other. Or daughter more mad at the son because he's going to take over. Mm-hmm. And dad and mom are trying to handle this dispute. Mm-hmm. You probably see that happen a lot. How does that, as far as your estate, how do you work that out?
That's a tough one. And I've actually been involved with a few of these where they end up in litigation.
Right.
Mom and dad have to come to a hard decision. Who is best able to go ahead and run the company? And for that matter, will it survive? They may be educated, but not everyone is fit to go ahead and run the company. Most of them fail.
Right.
When we go ahead and pass to the next generation. And what we've done in the past is that the people that have been there that know how the business works, they're involved in the day-to-day, the ones that we think are going to be able to keep the business going, we do evaluation of that company. And when we're trying to figure out how is the estate going to be distributed when mom and dad die, we may just end up giving the business to that one child or children who are best able to go ahead and manage the company. That doesn't mean that the others are left out in the cold. That's why we do the valuation. So you have to find a way to go ahead and equalize the distributions so that people feel that they're treated fairly.
Well, equalization at death means life insurance,
That's
but
right.
How do you equalize it during the course of the business before mom and dad do pass away?
Well, it could be a matter of compensation.
Okay.
That's one way of doing it.
So distribution from profits or?
Distribution from profits. Or if we're looking at a taxable estate, maybe there's some other assets that you could go ahead and start gifting during life.
Yeah, that makes sense.
Yeah.
All right. in terms of business, anything else you should tell me about the estate and business that you can drip on me right now? We're going to have an episode about succession planning down the road, but is there anything more, Bob, that you could tell me about business in your estate that we should probably know right now?
Yeah, the one thing that I see is a lot of people don't have buy-sell agreements in place or shareholders agreements in place that talk about, and we're talking about in situations where you're a co-owner of a business. What happens to your business interest when you die? Is your spouse going to go ahead and take it over? Because a lot of times your partners don't want to be in business with your spouse. But
Correct.
At the same time, you went ahead and you put your blood, sweat, and tears into making the business work. Your family should be compensated for it. They should be taken care of. And that's how we take a look at the buy-sell agreements and the shareholder agreements to go ahead and make sure that happens.
Yeah, we're going to have an episode on buy-sell agreements down the road, but I appreciate that heads up. Thanks, Bob. Is there anything else?
No, that's all good. Thanks.
Well, thank you for joining me, Bob, for this episode of Wait, What? Financial Matters that Matter for Businesses and the People who own them. You can always contact me to get hold of Bob through eb@wait-what.biz. With fourth quarter medical renewals coming up, next week's episode is going to be a good one for you with Allison Ramirez and a company called Insperity. Thank you.